of the afternoon is going to send us live, and now we're live. So, yeah, let's hear what people are thinking about what we have in front of us or not in front of us. Representative Bosland, do you want to start?
Yeah, I mean, I guess I have a thought. I mean, we have all been receiving all these messages and I don't know most of these folks. So I've been doing some looking them up to try to figure out like what their backgrounds are, what kind of farmers are they? And the huge majority of them are giant dairy farmers. And then there's some giant corn farmers. And then there's a handful that are people who had issues with environmental problems that have gone to court and were, I don't know how those were resolved. But I guess it makes me concerned that we're not hearing from the people that I've been sort of raising questions about is the smaller farmers and do they like this? And I mean, I did get some emails from people who were saying they were smaller farmers or organic farmers and they had concerns and they think we should go slowly. I mean, the legislation we've worked on, it feels like a lot of it is okay, but it seems like the people that are most enthusiastic about it are the ones who are potentially the ones who could end up causing harm to smaller farms. So I guess I still have some questions.
Representative Burt?
Yeah, I think the main shifts between current statute and what this bill proposes, I like the fact that it allows farms to adapt to new methods and still be covered. And I guess I'm not so much thinking about size of farms. I'm thinking about farms in general and trying not to think about scale. Not because I don't think that's important, but because I think I'm hoping the bill would neither prevent or necessarily encourage scale. I think I just wanted to address nuisance, right? So I guess it might be hard not to put bias into a viewpoint, but I'm trying to just come at it with those eyes. And I'm grateful that it doesn't, that allows farms to adapt to new methods. And that if someone is coming along, with concerns, those people that come along with concerns are the ones who have to, do the work.
Mhm.
That makes sense to me. I think those are two things in the right direction. And I think those are probably the most important two. So I'm liking what we've got in this bill right now for that reason.
I think that I commend the committee's work and the drafting process of this bill. I think that if I'm looking at it from a historical perspective, that the need for updates doesn't tend to match the pace at which litigation is actually occurring. I think that to separate the concerns around scale, ignore the deep impacts that come with increases in scale. I think that saying that this is merely a bill to protect farmers from nuisance is a convenient simplification that acknowledges a trend in consolidation. I think this is a values-based question. I think this is what are we trying to support for an agricultural industry in Vermont? What are we wanting to be as a state? How can we actually give farmers the right to farm? And I don't think that this would be not only not my preferred avenue, but I think that it is deeply misleading. And I have struggled from the onset with this bill, but I'm grateful for the reflections of the committee and for the work. But it is not something that aligns with my own values and how I farm.
Okay, thank you. Representative Baldwin.
Add or subtract?
Then Representative Lipsky.
Yeah, I'm actually focused a lot on current challenges. And we're charged with being part of a broader regional obligation to feed New Englanders as well as Vermonters. And we've all watched small farms disappear from our landscape, and large farms or consolidation is part of the trend. That's an aspect of survival, still keep producing. To me, agriculture is one of the most important historical as well as for our future. Obligations of an agricultural state where we will have the climate and the land produce food. I've watched in the forestry world, the total loss of capacity and quite frankly, hostile attitudes toward active forest management. I don't believe it's guided in science, more emotion. And we've also taken a lot of testimony regarding farms by necessity, having to adapt to new technologies, new requirements. They have to innovate and diversify in order to survive. And we've heard a lot of testimony about how many new small farms. It's a very large and growing portion of our farming community. And I would wholeheartedly support this bill as it's discussed. Yeah, and I'll leave it at that. I'm for it, would like to see this bill passed this session.
Thank you. Representative Nelson.
You ready? Saturday, I went to Moores, New York, to pick up Hartford farm plan and did a 400-mile roundy, 370-mile roundy, something like that. But anyway, on my way back, I swung down Middle Road in Swanton because a young lady has a small strawberry patch and an accessory farm structure to sell strawberries out of, and she's being sued. I talked to her. She said she was going to email in. I didn't hear from her. Brittany Shum. I shouldn't say her name. Anyway, got a beautiful place, doing a beautiful job, and it's a shame. And I told her I'd help her any way I could. This bill would remove everything for her. That being said, the issue of trespass, I'm still vague on it, but we're protected from nuisance from our normal agricultural practices. And as we heard the professor from Vermont Law School explain, you have an obligation to let rainwater leave your land, and your neighbor has an obligation to take it as long as you don't create a new conveyance for that water, that it runs where it never ran before. So, and that makes a lot of sense to me. And it's made a lot of sense to me ever since he said it. Page 3, line 3, I think that needs to say final order. And page 5 and page 6, page 5, lines 19 and 20, the adverse effect of health and safety welfare. And that was kind of in the bill previous to this. And I liked it better when later on it says the state can make that determination. In page 6, lines 1 and 2, the activity has a noxious or significant interference with use and enjoyment. And that one, bothers me a little bit. I mean, I suppose if you go back to, using acceptable ag practices and I'm in my RADs and whatnot. But that line 1 and 2 is exactly the definition of, am I a nuisance or not? We don't spread manure the week of the 4th of July back in town. Cause that'd be a nuisance. And we realize that. I also realize further down, before anyone has a right to sue, but we go through mediation first. So that relieves a lot of things as well. So, yeah, I'm happy, I guess, or consent to the changes that we made. I think, I'm surprised. I'm fine. So just those couple things, the final order would be the big one.
So, that's on page 3, at the bottom of the page. That's number 3, yeah. Let me just get a sense of the rest of the committee. Does anybody else feel strongly about not putting the final order requirement back in?
I don't understand what that means.
Yeah, so let's talk about that a little bit more then. Right now, so the language that's up here came from judiciary, but the judiciary had added, included, Mike, maybe you can say it better than I can.
Sure. So generally, the definition of good standing with the state for agriculture means that the farmer does not have an active unresolved enforcement violation that has reached a final order stemming from the agricultural activity. And what that means is the farmer's been notified of a violation. They've been told what they need to fix. Maybe they've been given a schedule of compliance because maybe they need time to do it. It's not the right time of year, but not, weather conditions, et cetera. And they don't do what they're required to do when they're noticed. The agency often gives them a second chance to do what's required. And if they don't do it, then they can move to an administrative order, court order, requiring them to comply with the law. That's the final order.
So that language is, the words final order are missing right now.
Words final order are missing right now.
It doesn't seem like it would be problematic to me to put that back in.
So putting that, the impact of putting that back in would mean that it's easier for the farmer to produce the certificate. Right?
Correct.
Yeah. So that if there's some sort of a violation or an investigation that A&R is looking at, or that ag is looking at, that's not going to prevent the farmer from saying, I'm a farmer, I can do this, get away with this, I have this protection. Only if it's reached the point where there's final order, then that would make it harder for the.
They may have received a notice of violation and instructions on what they need to do to come into compliance. With that said, both agencies have the ability to act right away if there is the determined need to protect public health, safety, or the environment. So they don't have to work with the farmer. They can move immediately to an order stage. That's usually for a more pressing issue, but it's always on the table.
So is it kind of about where you are in the process?
It's where you are on the process, and it's about recognizing that the General Assembly has told the Agency of Agriculture to work cooperatively with farmers to bring them into compliance.
But does that mean if something is appearing to be problematic and the Department of Ag says, wow, this seems like there's a problem, you're going to have to do better. If they're saying, do you have to do better? Does that mean they already have an order? Or is that like is a warning, not an order?
They have the notice of violation. The notice of violation letter tells them what they have to do,
Yeah.
why they are, it literally says the law that it's violating, a time frame for coming in to compliance, et cetera. And then they're given that, but say it's something like your manure upon your waste storage facility is leaking and it's runoff is going into a water, and like A&R can come in and say, you need to fix that. And if it's significant enough, they can tell them to do it right away. They can go and say, you have to resolve that issue under an order. And while they're under that active order, they wouldn't be in good standing.
So that's considered a final order.
Yeah.
If they've said, if they give you a clear direction that you have to follow, that's a final order.
And does that get lifted at some point? And so when would the farmer then be freed of that?
And it's no longer active when they've complied.
Once they've complied, then they could get their certificate,
Well,
or they get whatever they get.
I mean, they wouldn't be able to have asserted nuisance protection when that litigation was brought, so.
Okay. Greg.
For my final clarification, as it's written right now, if somebody's in the middle of something like that, they don't have nuisance protection during that period of time.
Not the way that it's written right now.
Okay.
So you put in that has reached the final order stage, they would, unless they've had a final order.
Can I ask Steve a question?
Sure.
What's the typical of the time that, where there's, a farmer might be in violation and how long it takes to get resolved?
Sure, Steve Collier from the Agency of Agriculture. I mean, it really varies depending on what the issue is, but the final order is it's really just allowing the farmer the opportunity, as Mike talked about, to correct the violation. But it's also a due process consideration. When we issue a notice of violation, the farmer can ask for a hearing. And then if they have a hearing, they have a right to like a mini trial, and the hearing officer will decide whether or not they're responsible or not. So a lot of it is about, ideally, the farmer is complying, and that's usually how it goes, and we're working toward that compliance. But if we can't reach an amicable resolution of it, then the farmer has a right to have us present our evidence and for a hearing officer to determine whether or not whether the violation is substantiated. And if it is, that's when there's a final order. After the hearing, the agency will issue a final order. And at that point, the nuisance protection will be filled. Unless the farmer corrected it. But just if I may quickly add, this whole thing is a little bit circular because the whole good standing requirement, if someone, the way you constructed the bill, if you are allowing a violation of the RAPs or the pesticide rules to constitute a nuisance, then no matter what the agency does with the final order, if the farmer is violating the rules and the plaintiff can prove that, that's going to sustain the nuisance violation. So the good standing, and we don't have a problem with it, but we don't really think it's helpful. And it just kind of creates another administrative piece that the farm has to go through, because if the plaintiff can show the violation, then the nuisance protection doesn't apply. So it's not a bad thing, but it's probably superfluous.
So is this,
Superfluous? And I didn't say that very well.
That's a new $5 word for it, okay?
thank you, Steve. So, Mike, is this what sometimes would be called a belts and suspenders section?
Bootstrap, yeah.
Before we wrap up here or move on, can we just go back to the findings section at the top? There are a couple of things that I noticed when I just wanted to flag them. So this is existing statute. I think that I saw that this language dates back to, so this original section of the law was written in 2004 or so.
Originally, I need to check on, the legislative history. I think it's before that, this section at least.
There were some amendments in 2004, I think, but
Yeah.
maybe this goes back to even.
Because before that,
So it's just, I think one thing, it's notable that the concerns or the findings that are here are not new. In fact, they're at least 20 years old, and we're still working with them. And so when we talk about liberally directing the courts to liberally interpret and using our findings and intent, you know, this is, they're going to be looking back at this. At the bottom of this page, it says, in order for the ag industry to survive in this state, farms will likely change. So farms will likely change, adopt new technologies. And can you go to the next page, Mike, while you're searching there? And diversifying new products, which for some farms will mean increasing in size. So get bigger. And then the next sentence, the assembly finds that ag activities are potentially subject to lawsuits based on the theory of nuisance, and that these suits encourage and could force the premature removal of farmlands and other farm resources from ag use. I got a little hung up, I will say, on that section, that these suits encourage the premature removal of farmland and other farm resources from ag use. I'm not sure that I could point to any data that would support that particular claim. It's the purpose of this chapter to protect ag activities conducted on the farm from these lawsuits. So anyway, this is not new language. Again, it's in the bill, so we're not proposing any change, but it provides the framework and the context for why this statute even exists. And it's just interesting to see what was said 20 years ago. And in the way that we're still talking about it in the same terms.
so the original findings section was 1981. But it was amended in 2004. And I will have to, because 2004 laws are not very easy to find, gonna have to do a little, it'll take me 5 minutes, but.
Well,
Just comment on your. Yeah, it was actually interesting that maybe 40 years ago, there was already consolidation, and there's certain economies of scale. As tractors go from 3,000 for a Ford 8N to a $700,000. That naturally, because of the rising costs of production and investment, that a lot of reasons why small farms really since the 1960s have disappeared from the landscape.
it's interesting that even though this 20 or 40-year-old language said it's a finding, farms are likely to change new methods of farming diversity, that we didn't provide the protection to those farms back then.
It's different sociologic makeup of the state then.
Okay.
So I can read to you what it was in 1981 if you would like.
Yeah, so let's have that history lesson.
It might take a little bit, but the legislature finds that the agricultural production is a major contributor to the state's economy. Agricultural lands constitute unique and irreplaceable resources of statewide importance, that the continuation of agricultural activities preserves the landscape and environmental resources of the state, contributes to the increase of tourism, furthers the economic self-sufficiency of the people of the state, and the encouragement, development, improvement, and preservation of agriculture will result in a general benefit to the health and welfare of the people of the state. The legislature further finds that agricultural activities conducted on farmland and urbanizing areas are potentially subject to lawsuits based on the theory of nuisance, and that these suits encourage and even force the premature removal of the farmlands from agricultural use. It is the purpose of this act to protect reasonable agricultural activities conducted on farmland from nuisance lawsuits. It's not that different.
Yeah, it's not that different.
The sentence, in order for the agricultural industry to survive in the state, farms will likely change, adopt new technologies and diversify. That was from 2004.
All right, so I'll just say that I'm hearing, some people are wishing that the bill did slightly different things than it does. Some people are, I think, expressing that they think it's in a pretty good place. There's a suggestion that maybe we would need a little more time to digest it all. We have made some changes. I will say that I recognize that it maybe strikes a balance is not the right expression, but that it doesn't necessarily won't satisfy everybody. Things usually don't. Otherwise, we wouldn't be here. We'll come back tomorrow at 9:30, and we're gonna, Mike, I don't know if you'll be available tomorrow, but if you are able to just make that one change with the
Final order.
the final order, then if we're comfortable with that, we can go ahead and take a straw poll on that for judiciary. We'll also be looking at H401 tomorrow. That the Senate voted that out this morning. So it'll be coming back over to us to see they did amend it. So we're going to hear from the Ledge Council, which has been walked us through the new language. We'll hear from the bill sponsor, not Mike, different Ledge Council. We'll hear then from some witnesses, the health department being one that might want to testify, and maybe from, we haven't lined anybody else up yet, but we can see who else the committee might want to hear from. Because there are some changes on that. So that'll be tomorrow. I don't imagine that we'll be coming back to the committee after the floor. Tomorrow's gonna be a very short floor. So if we can get our work done in the morning, then those who need to leave for their day jobs can do that. All right, thanks, everybody.
Economic poison.
We're all set.